Good morning, everyone, and thank you for joining the Burness Paull Junior Energy In-House Lawyers webinar series. Our first session in the series will be an overview of the current legal trends in renewable energy projects. My name is Olivia Smith, an associate in the Renewable Energy Real Estate team at Burness Paull, and I will be one of your speakers today. A little bit of housekeeping before we begin. Once you've joined, please ensure your mute button has been selected to limit background noise. Today's webinar won't be interactive, so please contact the relevant speaker after the session if you have any questions. Today's webinar will be recorded. If you have any queries about this, please check out our privacy policy on the Burness Paull website. I'm going to kick things off this morning by running through some of the current legal trends we are seeing from a real estate perspective at the option or pre-lease stage of a project. Firstly, the item on everyone's minds at the moment is grid reform, and my colleague Jordan Galbraith will discuss this topic in further detail shortly. From a real estate perspective, the key focus for our clients is being able to demonstrate that they have secured sufficient land rights so that their projects meet the land element of the Gate 2 readiness criteria. To do this, projects will need to meet the minimum acreage requirement for 100% of the project site and also provide evidence that they have secured land rights for the required land, i.e. at the very least have entered into an option agreement to lease or acquire the project site, along with a red line boundary plan of the project site. Under the new proposed regime, a Gate 2 offer would confirm the connection date and queue management milestones. Developers will be required to satisfy specific planning and strategic alignment criteria, in addition to providing they have secured sufficient land rights in order to apply for a Gate 2 offer. If developers are unable to meet the Gate 2 criteria, they would only be able to obtain a Gate 1 offer, which provides only an indicative connection date, translating as a later connection date for many projects. It is therefore key for our clients to complete option agreements for project sites as soon as possible over the coming weeks in order to meet this Gate 2 criteria and bolster the viability of their prospective projects, something that will no doubt keep us all very busy for the next little while. Turning to natural capital, government policy is becoming increasingly underpinned by natural capital thinking, driven by a growing recognition of ESG criteria. The woodland and peatland restoration carbon credit schemes are up and running in Scotland, with the market expected to develop rapidly to catch up with the opportunities south of the border. As a result, we're finding that landowners are wanting to keep their options open regarding future development of natural capital schemes on their land, particularly at option stage. Developers should therefore be alive to the fact that landowners may request the ability to develop natural capital projects alongside any renewable energy projects. The industry position on this form of co-location is far from settled, with option agreements typically containing an agreement to agree approach to natural capital should a landowner wish to pursue it in the future. However, the requirement to factor in the landowner's natural capital ambitions into the negotiation of renewable energy land rights is no longer uncommon, with developers now being faced with the prospect of negotiating interface between their proposed project and hypothetical natural capital schemes, in addition to more traditional interfacing with existing third-party users of the land or neighbouring projects. With regard to land ownership structuring, land ownerships wishing to structure their ownership in the most tax-efficient way possible is not a new phenomenon. However, in anticipation of and following the autumn budget in October 2024, we have seen landowners taking a significant renewed focus in the structure of their land ownership. Most commonly, we see landowners wishing to alter their land ownership structure before completion of the option agreement. Grant of planning permission is also another key milestone influencing a landowner's approach here, given the resulting impact on land valuation. There are two main impacts of land ownership restructuring on developers, being costs and time. Landowners will often request that the developer fits the bill for the landowner's legal fees for this exercise, with contributions towards a landowner's tax bill also being requested, although not necessarily accepted. In terms of time, if restructuring is to complete in advance of the option agreement, this may well delay completion of the option. If this situation arises, it would be recommendable for the developer to oblige the landowner to complete the exercise within a certain period of time via pre-completion missives to avoid unnecessary project drift. I'll now hand over to my colleague, Marianne Wilson, who will discuss current trends at lease stage.
Thanks, Olivia. Hello, everyone. As I said, my name is Marianne Wilson and I'm part of Burness Paul's Renewables real estate team. I'll be covering key real estate trends that we're seeing at this stage of developments. So starting off with co-location of technologies. In order to fully utilise land, we're seeing developers entering into multi-technology projects with combinations of wind, solar, hydro and battery storage. With different technologies installed within close proximity, a key question from the point of view of a developer is whether they need the ability to operate, fund, or even sell as separate projects. We're often asked by our developer clients to retain the flexibility to run projects as one or separately within the land documents. But there are crucial considerations if the developer wants to be able to laterally separate out and run as different projects, which definitely makes the documentation a lot more complex. For example, how is the rent to be calculated for the different technologies? Wind is usually calculated on an installed capacity basis, whereas solar is normally calculated per acre of land utilised. Developers need to ensure that they aren't inadvertently double counting their rental payments. And so ahead of term stage, we're seeing increasingly complex rental terms being agreed, including complex gross income definitions to explicitly state the deductions that are to apply for the purposes of calculating operational rent. For example, import charges from the grid or deductions for battery storage purely used for powering the project itself. These meticulously negotiated terms need to then be accurately and securely reflected within the drafting in order to capture the agreed position with the landowner. We're also seeing a lot of interfacing between projects. Given that viable land is becoming increasingly sparse, developers will often need to work collaboratively with neighbouring projects to guarantee efficient use of the land. We're seeing this particularly in respect of access for multiple developments and also shared infrastructure from network operators. The difficulty here is that landowners are increasingly pushing for the rights granted under the lease agreements to be specific to particular projects and developments. They want to know who will be operating on their land and what the rights being granted are being used for. In terms of network infrastructure, landowners are trying to put specific developers on the hook in the event that infrastructure is being used for other projects. And as a result, we're frequently having to explain that network operators rely on statutory powers to prioritise their obligations to connect multiple projects. Ultimately, it's to the network operator's discretion. And in terms of access, main questions here are which developers to get priority and who is on the hook for maintenance. Is it to be a shared responsibility according to use, or does the developer who constructed the access want to have full discretion over its maintenance and renewal? We're also frequently dealing with extensions of projects at this stage, including life extensions and repowering. With advances in technology, we're seeing leases being entered into for much longer periods of time to account for improved lifespan of projects. Again, a priority here is figuring out how the rent is to be calculated at extension stage and how it is to be fixed or secured as much as it can be at this stage. In terms of rent reviews, landowners have been pushing for open market reviews, which often exclude a downward evaluation. In these circumstances, developers are left with an element of uncertainty as to what the rent payable will be as and when the extension is triggered. With significant market volatility, developers need to consider how best to secure viable projects for years to come without engaging in an uphill battle to tie landowners to fixed rents, particularly when future markets are unclear. With that swift canter through some of the key trends and aspects to consider at lease stage, I'll be passing on to my colleague Gemma to take us through some key planning trends.
Thanks, Marianne. So I'm Gemma Hughes and I'm a solicitor in the Planning and Environment team at Burness Paul. Today I will be discussing trends in consenting, covering 3 topics. I will start by outlining the various consenting regimes. I will then highlight a few legislative and policy updates, and I will end by discussing common consenting concerns. Turning to consenting regimes, planning is devolved, so the consenting process is different in Scotland to England and Wales. I will be focusing on Scotland. There are 2 consenting regimes for energy projects in Scotland. The first is found in the Town and Country Planning Scotland Act 1997. In this consenting regime, permission is granted by the local planning authority. The second consenting regime is contained in the Electricity Act 1989 in which consent is granted by the Scottish ministers. The appropriate consenting regime differs depending on the type of technologies involved and the scale of projects, which will be discussed further in our April webinar. However, for the purposes of today's session, it is worth noting that there are different decision makers, legislation, policy considerations, and timescales involved in both regimes. Having an awareness of recent decisions, as well as an understanding of the legislative and policy framework, is essential to developing a consenting strategy that will allow for a project to be delivered in time. Now moving on to my second topic, which is legislation and policy. Consenting is a continuously developing area of law and policy. Changes in law and policy greatly impact the timescales involved in the consenting process, the information required, and the likelihood of permission being granted. Due to this, in the planning team, we regularly provide advice to developers on the evolving legislative and policy landscape, as it greatly impacts on the viability of projects. In terms of legislative developments to be aware of at the moment, a consultation took place before Christmas proposing reforms to the Electricity Act. This would change the consenting regime for large-scale energy projects that are dealt with by the Scottish ministers. The consultation proposed various changes spanning the consenting procedures from making pre-application consultations a statutory requirement to changing the provisions around automatic public hearing inquiries if a local authority objects to a project, to reducing the period for legal challenges to consents to 6 weeks. Another proposal being consulted on is that the Scottish ministers would have the power to modify, suspend, or revoke consents without an application where there's been a change in the environmental circumstances or relevant technology changes, or it is necessary to correct errors in consents. This proposal could result in more uncertainty for developers. Undoubtedly, developers will have to continue to have an awareness of this changing legislative background and react to any changes in procedures as required. Not only is the process for obtaining consent changing, so too is the planning policies that decision makers consider when determining planning applications. We are anticipating the arrival of the Energy Strategy and Just Transition Plan shortly, which will be an important policy document once published. However, a notable planning policy development in recent years was the adoption of the 4th National Planning Framework for Scotland in February 2023, commonly known as NPF4. The adoption of this policy has led to somewhat unexpected decisions, which has resulted in planning appeals and judicial reviews being taken to clarify how different policies should be interpreted. This has undoubtedly impacted on the delivery of projects in terms of timescale and viability. Moving to my final topic, common consenting concerns. As highlighted throughout this brief introduction, consenting is an evolving area of law and policy at both UK, Scottish and local authority level for both onshore and offshore, which inevitably creates uncertainty for developers. A recent example of this is NPF4 includes a policy test that any new renewable energy development proposal should maximise net economic impacts. There has been no national guidance on what this means, which has resulted in some councils adopting policy positions on what they should be looking for in terms of local economic benefits. For developers, this presents a very steep increase in development costs in certain areas that may well go to the viability of projects. Thanks for your time. If you have found this useful, I'll be discussing current consenting issues further on 30th April. I'll now pass to my colleague Jordan to discuss energy regulatory changes.
Thanks, Gemma. I'm Jordan Galbraith, an associate in the energy team, and I'll be covering the reg issues around renewable projects. In terms of issues, the major one we're discussing with clients is the new grid connection reforms. I'll try to cover this as best as possible at a high level and in more granular detail for our session in October. So currently the grid connection application process in the UK operates on a first come, first served basis. There are only a few entry barriers to the current queue, resulting in it being heavily oversubscribed, such that projects joining the grid connection queue today would typically expect to receive a connection date in the late 2030s or even later. Long delays in achieving connections are causing a material impact on UK renewable projects and are not aligned with the UK government's Clean Power 2030 action plan. A significant aspect of the connections reform is the introduction of gating criteria for connections to the transmission system, as mentioned by Olivia in her section. This approach will replace the existing first come, first served model with a more strategic first ready and needed first connected system. The implementation of these gating criteria will result in a reordering of the current connection queue, prioritising projects that are considered most viable and necessary. The one-off gate 2 to whole queue process will result in a reformed existing queue, and then, with some exceptions, projects in next gate 2 tranche will be added to the end of that existing queue. A gate 1 connection offer will be very much a bare document with no connection date or construction schedule, and merely the first stage in proceeding to connection to the grid. The system operator sets out in detail what projects will need to demonstrate in order to be allocated a confirmed connection date, connection point, and queue position. To secure a Gate 2 offer, projects must meet specific criteria. These criteria are divided into two categories: readiness and strategic alignment. For a project to be considered ready, it must hold land rights, as discussed, or if following the development consent order process down south, have submitted the validated application for planning consent. Additionally, the project must satisfy one of a number of strategic alignment criteria, being eligibility for relevant protections, for instance, due to proximity of connection date or significant project progression, which could include holding a contract for difference or a capacity market contract, alignment to the capacities in the government's Clean Power 2030 action plan, or being designated as described in the system operator's project designation methodology. In terms of distribution for the Gate 1, for the one-off Gate 2 to whole queue process, the exercise discussed above will be provisionally conducted by each local network operator for their zone using sub-queues for small and medium embedded generation only. The system operator will then assess large embedded generation. The system operator has announced a temporary pause on all transmission connection applications effective from 29th January until the first new application window. This pause is intended to allow for the implementation of the new gating criteria and the reordering of the current connection queue. The system operator's impact assessment indicates that the aim is to go live with implementation on the 1st of May 2025. The system operator then intends to start issuing Gate 1 offers from Q2 2025 and are committed to issuing Gate 2 offers by the end of 2025. Overall, having discussed with developers, the biggest concern is whether this is going to harm viable and needed projects' ability to proceed. The transition period seems to be a very challenging one given the timescales, which could damage the viability of otherwise sound projects. And another concern was that strategic alignment might see winners unfairly picked, or that a lack of codification was seen as unfairly raising the barrier to entry through regulatory complexity. And so that was a very high level overview of the current connection reforms, but I'm hoping to go into more detail once the reforms have been implemented in October. In that case, I'll pass over to my colleague, Rory.
Thanks very much, Jordan. My name is Rory Henretti, and I specialise in renewable energy M&A transactions. Together with my colleagues, I've advised on a number of corporate acquisitions of wind, solar and battery storage projects. One of the key features of these transactions is the concept of ready to build, often shortened to RTB. Where a project is ready to build, that usually means that all of the necessary pre-construction hurdles have been overcome and a developer can actually begin to work on the site. These pre-construction hurdles typically include three main elements. You have your land rights, so that means you have somewhere to build your project. You have your planning permission, so you've actually got consent to build it. And finally, you have your grid connection, so that means that once you do build it, you can then sell your electricity. In the early days of the market, if you called a project ready to build, you meant exactly that, and the project coming to market then were often very close to achieving that ready to build status. As the market has developed and matured, the concept of ready to build and how buyers and sellers deal with achieving ready to build status in a transaction has actually evolved. One of the key drivers for this evolution is that projects are being brought to the market at a much earlier stage of development, and this is something that our team has seen a lot of in the past year or two. When selling or acquiring an early stage project, there's lots to think about, and in particular, you'll need to consider a transaction structure that reflects your chosen project's stage of development. So what are the trends that we've been seeing recently? Well, a number of recent transactions we've worked on have involved early stage projects, and in particular, this has involved on the land side, option agreements that are still being negotiated or might need to be amended. As Marianne mentioned earlier, this might be because parties are looking for some more flexibility, often to accommodate for multi-technology projects. For example, you might have a battery storage element that is being tagged on to a proposed solar project. On the planning side, we've seen consent applications that have not yet been submitted, or they've maybe only recently been submitted, so there's a bit of time to run. We've also seen transaction structures allowing for the expiry of judicial review periods, or clients considering whether judicial review insurance is an appropriate alternative. To cater for these earlier stage projects, buyers and sellers are coming up with some creative transaction structures which, in some cases, can involve greater buyer and seller involvement in those pre-construction processes. As the steps to achieve ready-to-build status are subject to the control of third parties, there is no guarantee that a project will reach RTB status. For example, planning consent will need to be determined by the relevant planning authority, and the negotiation of land rights will involve the landowner, or in some cases, multiple landowners. Buyers and sellers are therefore looking at different ways to balance the risk of a project not reaching RTB through the structuring of their transaction. Depending on the status of a specific project, we're seeing the parties agree to one of the following structures: a split signing and completion, a deferred consideration structure, a put option, or a call option. The first two structures I mentioned are the most conventional route for acquiring a project and are something that many of you are no doubt familiar with. The first is a split signing and completion, which means that the parties will sign a conditional purchase agreement where the buyer will then be obliged to complete the acquisition once a set of conditions have been satisfied. These conditions would typically include the achievement of the three ready-to-build components I mentioned earlier, being land rights, planning consent, and a grid connection. The second approach is a deferred consideration structure. Here, the parties will sign and complete an acquisition simultaneously, but the buyer won't actually be obliged to pay the bulk of the purchase price until the ready-to-build components have been achieved. We'll be covering these two structures in more detail in our webinar in September, but they are by far the most common and conventional approach to acquiring a project which hasn't quite reached ready-to-build stage at the time that the parties are looking to do a deal. The third route, which is less common, involves the parties agreeing to a put option or a call option. Over the past year or two, we've seen these used as a creative approach to structuring a transaction, especially for those projects that are coming to the market at a much earlier stage in their development. The put option approach would mean that the parties sign and complete the acquisition, and the buyer takes ownership of the asset or the shares before the project reaches ready to build. If the project then fails to achieve ready to build, the buyer will then have the opportunity to put the shares or assets back on the seller, obliging the seller to buy them back. Alternatively, the call option route would mean that the parties enter into an agreement which allows the buyer to purchase the project once certain milestones have been met, with these milestones typically being the ready-to-build triggers I mentioned earlier. We've seen both of these approaches as a rare alternative solution where a seller might not have the resources to develop the project to RTB stage, so they might therefore look for a buyer to become more involved in getting the project to ready-to-build status by becoming involved at an earlier stage. We've also seen this structure where a developer and investor is looking to secure a pipeline of projects in line with an overall investment strategy. As a general concept, put options and call options are quite straightforward. However, agreeing and implementing them can actually be more challenging. Given the time it might take from agreeing an option until it is actually triggered, there's a greater risk for the landscape to change. There might be changes in the market, such as cost increases, or the priorities of the buyer or the seller might change during this period. As a result, the parties will try to protect themselves against this risk, leading to additional negotiation and additional documentation. The key issues we often see are, in terms of consent rights, the buyer in a call option scenario might want to limit the activities that a seller carries out during the auction period, such as taking on debt or incurring certain costs. Security over shares or assets. In a call option scenario, security is often sought by the buyer to ensure that shares and assets haven't been disposed of or encumbered by the time they come to trigger their option. And we also might see some positive obligations in a put option scenario, as the seller will want to ensure that once the buyer takes ownership, they actually develop the project so that it gets to RTB and the seller ultimately gets paid. Balancing the interests of the parties during this interim period can therefore be a challenge and will often be the subject of significant negotiation. A put option or a call option is therefore typically only used to solve the very specific needs of a buyer and seller, and for those reasons, we tend to see those less frequently. As you can see, there's lots to think about when structuring a transaction, and these considerations are only going to become more important in a developing market. For 2025, with grid reform on the way, as Jordan mentioned, we are expecting to see investors focusing on projects with priority places in the connections queue. We're also expecting to see a continued interest in proven technology projects, especially co-located projects, with secure revenue streams through CFDs or corporate PPAs. If you'd like to know more about transaction structures, please join us at our webinar on the 24th of September. I'll now hand you back to Marianne.
Thanks, Rory, and apologies for that brief blackout you might have seen on our screens. With that glimpse into each of our energy practice areas, I'd like to flag that if you'd like to hear more about any or all of the topics that we've covered today, or to get a deeper dive into the property, planning, regulatory, or M&A aspects of energy projects, our Junior Energy in-house webinar series has a number of further sessions coming up. On the 27th of March, Olivia and myself will be discussing frequent property pitfalls, where we will provide an overview of a number of real estate snags we're seeing come up time and again, and what developers can look out for. As discussed, our session today has been recorded, and you will shortly receive an email with a link to the recording for the session. You will also find a link to register for the further sessions and learn more about the programme. Please do use the link to check out these upcoming sessions and book your spots in advance. In the meantime, should you have any specific queries for any of us on the team, please do reach out to one of us using the details that are on the screen now. We'd really love to hear from you. I'd just like to thank you very much for coming along and looking forward to seeing you at one of our future sessions.